My case is Virgil versus the School Board of Columbia County in Florida. It can be found on page 366. Citation is Virgil versus the School Board of Columbia County, Florida, and United States Court of Appeals, 11th Circuit in 1989. So the facts of the case are 1985, Columbia High School designed a Humanities 1500 course for 11th and 12th grade students and prescribed a textbook that contained both required and optional readings for the course. Among the optional readings were Lysistrata and The Miller's Tale. In the spring of 1986, after the first semester had ended, parents of a student who had taken the class the first semester filed a formal complaint concerning the textbook, specifically objecting to Lysistrata and The Miller's Tale due to vulgarity and sexual explicitness from these works. After reviewing the complaint, a school board advisory committee recommended that the textbook be kept in the curriculum, but that Lysistrata and The Miller's Tale not be required readings. But the superintendent disagreed with the advisory committee's decision and recommended that either A, Lysistrata and The Miller's Tale be removed from the text, or B, the textbook as a whole be terminated from the curriculum. The school board chose option B and voted to remove the textbook altogether from the curriculum. In the fall of 1986, parents filed an action against the school board, basically saying that their decision to remove the textbook from the curriculum violated First Amendment rights. So the issues: this court presents the question of whether the First Amendment prevents a school board from removing a previously approved textbook from an elective high school class because of objections to the material's vulgarity and sexual explicitness. The holding: the courts decided that a school board may, without contravening constitutional limits, take such action where, as here, its methods are reasonably related to legitimate pedagogical concerns. So the rationale behind the decision: the courts applied the U.S. Supreme Court Hazelwood test to this case and upheld the school board's decision to remove the textbook from the curriculum. Previously, Hazelwood School District versus Kohlmeyer upheld the authority of a high school principal to excise or take out 2 pages from a school-sponsored student newspaper on the grounds that A, articles concerning teenage pregnancy and divorce were inappropriate for the level of maturity of the intended readers, B, the privacy interests of the article's subjects were insufficiently protected, and C, the controversial views attained therein might erroneously be attributed to the school. The Hazelwood standard helped the courts with their decision in the Virgil case in 2 ways. First, though the Lysistrata and Miller's Tale were optional readings, they were still part of the curriculum, and when applying the Hazelwood standard to this case, the public might reasonably perceive that the controversial views attained therein might erroneously be attributed to the school. It doesn't matter if they are optional or required readings, still part of the curriculum. It can still look bad for the school. The Hazelwood standard applies to this case, secondly, in that the motivation for the school board's decision to remove the text was related to the explicit sexuality and excessively vulgar language in the selections, which the Hazelwood case supports because the school can reasonably argue that the students have not yet reached an age that is mature enough for the content. Interestingly enough, it's important to note that a copy of the textbook was put in the library for anyone to check out, but is no longer connected to the curriculum, and all the other textbooks were locked away in a file somewhere. That's it. Thanks. Sorry I couldn't be there today.